So yesterday what did we do? Where were we? We were discussing the disqualification of directors. So we did quite a few things yesterday. We understood all these points, right? This thing, all these. So what are the quick revision? First point, unsound mind, competent court. Second, undischarged insolvent. Then applied to be adjudicated as insolvent and application is pending. Next one, convicted, offence, moral turpitude, otherwise. 6 months, 5 years. 5 years from date of expiry of the sentence. Then 7 years. If it is 7 years or more, permanent disqualification. Otherwise, 5 years. From which day? From the date of expiry of the sentence, not from the date of conviction. Then that call money thing, that's fine. Calls any shares, the company, and 6 months. So if you are not interested in the company itself, what's the point? You need to invest in the company, give some time to the company. That's the idea. Then convicted of an offence involving related party transaction. That also is there. Then he has not complied with subsection 3 of 152. Then not complied with provisions of 165. That we have yet to do. 152 is nothing but your DIN provisions. One second, I'll just put this back again properly. Yeah, any doubts still whatever we have done? Doubts, no doubts. So today we have to do the other areas. So yesterday we finished all the important areas of the other thing. One second. Today we have to do the other important thing of 164. Subsection 2. Yesterday we did which one? 1. So now we have to do 164 2. Sometimes they lose connection. Right. Cool. So all this we saw. Now, any shares, all that we have already seen, no tension. Now let us go to a very interesting area, 164 subsection 2. Then we'll come back to one. There are other points also that has to be seen. For example, is it linked to any, like after that question you may get, after you are entering the company, then if you do any of these disqualification points, then what happens? Will it lead to vacation is the question, right? What I'm saying is vacation can be a different section only, but disqualification is also there, no? For instance, after you become a director of the company, if you do anything that is involving moral turpitude and you are convicted, so can you still continue or will it only affect your reappointment? Every reappointment is a fresh appointment. So at every fresh appointment you have to see the disqualification. But during the tenure, let's say you are in the company for 3 years, during the tenure if you are convicted of moral turpitude, what happens? That we have to see. Is it linked in any way? That we have to see later. If these points are not there in 167, that is vacation, then you need not vacate. But if these points are there in 167, then obviously you have to vacate. We'll see that later. But first let's check out 164 2. No person, again, this person is individual or company? Individual. This is talking about director, so it is individual. No person who is or has been a director of a company. No person who is or has been a director of a company. Yesterday, taxman was down. Today it's working, thankfully. I hope. It worked. That's what. No person who is or has been a director of a company. So, if you see again, you see, I told you a company can be defined in any way, but literal is a company means everything. But government can give certain exemptions under section, yesterday only I told you, section which one? 462, correct? 469 is rules, 462 is exemptions. So, if you see, sorry, not this, here, see that. 164 for government companies it will not apply. Why and all we'll see later. So in this is the notification number 5th June 2015. This notification date is very important, guys. Why? Because on this day 5th June 2015 so many exemptions came, pages and pages of exemptions. For whom? Private company, some little bit of a public company, small company, one person company, section 8 company, like that, Nidhi company. So many exemptions came. So those exemptions have to be seen. Let's see. No person who is or has been a director of a company which has not filed financial statements or annual returns for any continuous period of 3 years. For any continuous period of 3 years. This thing only has gone off. No person who is or has been a director of the company which has not filed financial statements or annual returns for any continuous period of 3 financial years. Next, has failed to repay the deposits accepted by it or pay interest thereon or redeem any debentures on the due date or pay interest due thereon or pay any dividend declared, and such failure to pay or redeem continues for 1 year or more, shall be eligible to be reappointed as a director of that company or appointed in other company for a period of 5 years from the date on which the said company fails to do so. We'll see that. Now, tell me guys, financial statements generally should be filed when? Financial statement should be filed when? How many days from the AGM? 30 days? Yeah. So section 137 says that you have to file the financial statement within 30 days from AGM. What is the form number financial statement? There are e-forms, no? AOC 4, yes. What do you mean by AOC? What is AOC? AOC is nothing but the chapter name. This is chapter number 9, 137. Section 137 comes under chapter number 9. What is the chapter name? Accounts of companies. That's why AOC. Management and administration will not be MAT and all, MAT. No, it is MGT. Though similarly they would have named it. For auditor it is ADT. Auditor shouldn't ask why isn't it Audi 1, Audi 2. Correct? No, it is ADT. It depends. For incorporation chapter it is INC. Like that. AOC means accounts of companies. Then annual return should be filed when? annual returns is section 92 to be filed within 60 days from AGM. Annual return 92 comes under chapter number, this thing, what is that? Management and Administration chapter 7. So where will it come? This is MGT. MGT 7. Form number 7. Now, what they are trying to tell, has not filed financial statements or annual returns for any continuous period of 3 financial years. By a simple reading of that, what do you think? Should I file both or should I file only one? Read carefully. Online, both or one? Online friends, both or one? You should file both or you should file one? Somebody is telling one, somebody is telling both. So again here little bit of history we have to give here. 164.2. Always remember, knowledge of the past is guidance for the future. So we have to understand the past to understand the future. But anyway, here this is normal English. Is it 1 or 2? Online people, you are not replying only. Answer. Should I file both or only one? Both or only one? Here saying one, saying both. Okay, I'll just give a normal English, interpretation. If or is there, it's only one, no? Either or. If I say a person, a student who comes to class, or a student who has not brought the bare act or who is not wearing formals will not be allowed to class. Don't wear formals and come, I'm just joking. I'm just saying, a student who does not bring the bare act or does not wear formals will be thrown out. Means what? If he has, let's say he comes in casuals but brings the bare act, will he be thrown out? Yes. Why? Because I told a student who does not bring the bare act or does not wear the formals will be thrown out. If a student just wears casuals and comes with the bare act, will be thrown out. A student who comes in full formals without the bare act will be thrown out. Means there is double negative. A student who does not bring bare act and does not, come in formals will not be allowed in class. Double negative. And the double negative, when it comes, that or will become and. Means how will I read it? A student who brings the bare act and who comes in formals only will be allowed in class. A student who wears formals but does not bring the bare act will not be allowed in class. A student who comes in casuals but brings the bare act will also not be allowed in class. Got it? So a double negative will be positive. So that rule. One second. Here, page number 47. Read. No person who is or has been a director of a company which has not filed financial statements or annual returns for any continuous period of 3 financial years. Where there is a double negative in a provision, it converts into positive, or should be read as and. Hence, the above should be read as a person is qualified only if he files both financial statements and annual returns. Financial statement and annual returns. Got it? Now, if you see, we'll still have to discuss. Many things are there to discuss. Means he has to file both. Even if he doesn't file one also. Let's say he files annual account but doesn't file annual return, then disqualified. For any continuous period of 3 financial years. Now, any continuous period, tell me that any should be last 10 years any, or should I say only last 3 years? Logically. When I say any, is it previous 3 financial years or any 3? My company is in existence for 20 years. Should I see 3 out of 20? Disqualification should be seen every year or not? Yes, at the time of reappointment. Somebody will be reappointed every year, and every year I have to file anyway. So shouldn't I see every year? Yes. So don't you think so? I would have seen every year. I would have seen the past 3 years. Yes. So this any continuous period of 3 financial years should be read as what? Immediately preceding 3 financial years. Because practically every year I would check. Was this section there in 1956? Very much yes. Very much yes. Right? So, about the filing part, what should be filed, what should not be filed, we will see now how stringent it is now. Then we'll go to the past. So, here what they are saying, previous 3 years I need to see. They should have filed both. But if they have filed only one, then it is a problem. But that failure should continue for how many years? 3 years. So how to understand this? We will see this chart here, which I have made, which makes it easy for you. This is the thumb rule, page number 45. See, all this I used to make you write before, but this time I have put everything in the book because, it should be easy for you guys. I'll give you the history. There is a wonderful history for this. Okay, anyway, scenario number 1. Right? Different scenarios. Financial statement has been filed for a year. Annual statement that year is not filed. Is that a problem or no problem? Problem. Why? You should have filed both. Next. Financial statement not filed. Annual return filed. Problem, no problem? Problem. Both not filed, guarantee kirik only. Problem. Both if you have filed, then only no problem. Now the thing is, of the 3 years, when will it be a big problem according to you? I have to see 3 years. No, this I am seeing different scenarios. Every year there is a problem. Is there a problem? You understand? Every year if there is a problem, is there a big problem? Yes. But 1 year there is a problem, 2 years no problem. Is there a problem? Or should all 3 years, if it's a problem, only then big problem? What does the rule say? If you have not filed financial statements or annual returns for any 3 continuous financial years, means what? If 1 year there is a problem, it's okay. If 2 years it's a problem, okay. Third year also if there is a problem, then it's a big problem. Continuous years. Got it? It is very logical. 1 year if there is a problem, no problem. It's fine. It's a warning. Second year also you did problem. Big warning. 1 more year you do, gone. So what do you mean by a problem? Not filing one. When is there no problem? Filing both. So how do I see it 3 years? You see this. Now you only tell me. Page number 46. Year number 1, 2, 3. I am standing in the fourth year, that's of course because I am seeing the previous 3 years. I am seeing the previous 3 years. First year, tell me. Financial statement filed, annual returns not filed. Problem, no problem? Problem. Second year, problem. Third year, problem. Continuous 3 years problem. So, big problem. Disqualified. Disqualification status, disqualified. Are you getting it, guys? Very, very simple. Online buddies, hope you are understanding. Yes. Next, case number 2. Financial statement filed? No. Annual returns filed? No. Problem? Yes. Second year both filed? No problem. Correct. Third year both not filed? Problem. Did the problem continue for 3 years? No. So is that a big problem? No. Qualified, disqualified? Qualified. It will be easy for me to teach the history once you understand this concept. After this case 4, we'll go to the history. Case 3. First year, problem. Second year, problem. Third year, problem. I don't know, you're doing inky ponky. Correct? First year filed, next year not filed. But at the end of the day, all the 3 years, problem. Disqualification status, disqualified. Director should file or company? Company, no. If company doesn't file, why director is penalized? Yeah, all acts that has to be done by company should be done by director, no? Board. So I'm going to lift the corporate veil. There is a corporate veil that the directors are standing there and the veil is there, veil of incorporation. In many cases, I'm going to lift and make you personally liable. This is one of the examples. Lifting the corporate veil and making the directors liable. Generally, I can find the company. Company will pay, but why should company pay in this case? Because it is your job to file the annual return and financial statements. It should be a public document. People should be able to see the financial statements. God knows what you are doing in the company. So every company needs an audit. So please file an audited financial statement. Right? Next, case 4. Okay, 4 will come. We'll come to 4. Now we'll go for the history. Right, correct. Shirag, directors are the brain of the company. Yes. In 1956, no? Act. It was so relaxed. The disqualification provision was crazy. Any idea what it was? They said, of the 3 years, how many documents you have to file? 6 documents. Every year, 2, 2. Not filed, not filed, not filed, not filed, not filed. One you filed off. That's all. this was held to be qualified. Imagine. No disqualification. In 1956, the rule was very simple. Of the 6 documents, file at least one. 1 out of 6 documents. Correct? 1 out of 6 documents. Now it is not only that. It is what? You have to file both every year. If you don't file both every year, then it's an issue. So now instead of 1, you have to file what? 2. Correct. You have to file 2, at least to escape. But every year there would be a penalty now because you are not filing. So that other penal provisions will apply. Earlier nothing would have happened like that, all those things. Anyway, so people didn't give a damn. Companies Act was an underrated act that time. Now it is not. Even for CA final. Company law means, hey, it's okay, practice manual, will study and go. That was the attitude. Questions also were coming like that till my attempt, I remember. Mine was May 12 attempt. In my attempt, things changed. Complete case study based questions they started asking. That happened in my attempt. Till November 11, it was chilled out. May 12 onwards, slowly it started. But now it has reached a different level. If you see May 12 paper, no, you'll laugh now. I'm not joking. My paper, if you see, you'll laugh. What is this? Nursery rhymes. But at that juncture, for us, it was tricky because till November 11, practice manual, if you study, you would have passed. But May 12, they changed the trend. And it has been like 8 years now. 7, 8 years, whatever, 8, 9 years. So they are actually really increasing the level every single attempt. Attempt by attempt, slowly they are increasing the level. Which is excellent for us because we study from the Bare Act. For us, nothing can touch us because it is going to be easy. November 20, people were crying. It's very difficult, very difficult. My students text me and said, chiller paper. I was like, no, but others are telling, no sir, it was all, we understand the importance of Bare Act. It was so easy it was. We aram se solved everything. It was lengthy, but it's fine. Even 6D paper also, they closed their eyes and they wrote. So if you see, I've made like 2 books in 6D. It's an open book exam, by the way, right? Paper, the elective paper. So you can close your eyes and take those 2 books, correct? You take up paper 60 economic law only if you like law. Simply don't take. Correct? I have made a video which elective to choose. You can please watch that video on YouTube. Some fellows say, sir, your paper anyway, paper 4 is a 6D also I'll take. I'll say, boss, do you like law? Okay, sir, but I think it's core. No, don't think. What do you like? He told, I like income tax. Then take this thing, no, that international tax. Right? Please take what you like. Simply don't take 60 just because, it's there, it's same, it seems we'll take. It's not same. Methodology is really different there. But it is high scoring. But we are studying from Bare Act anyway. So I have made 2 books. So what to, take in the exam, sir, people say, whether to take 6D. So you see one student, Maitreya, okay, she thought I wrote 60, it was a cakewalk. She has only written here, live student. So yes, it was, because I've made 2 books. One has the Bare Act. Bare Act is there only. Open book exam, guys, what more do you want? Huh? Huh? Same questions came, I know, they told me. Case studies, whatever I gave, same questions. They also don't know what to give, no? They have to give from the whatever case studies are there only. So whatever institute has given in some 10 different books, have compiled everything into one, and my notes is also there. 2 books are enough. And there's an index also which, it's a different methodology, guys. It's a different methodology. It's fun. So what I'm trying to tell is it's different. So it's easy and it's fun as well. That's the thing. Last time what I did was the paper 4 people said, sir, IBC do the same depth as paper 6D. So I combined the 2. Generally in paper 4 I would have finished IBC in 10 hours. Last time I took 35 hours. So it's needed because the questions that they are asking here in paper 4 also are that level only. So that is the scene. But elective you take whichever you like. So you watch that video, which elective to choose. I have given you the history there of the marks and all those things. Don't blindly take 6D. Just I can push you, no, I can cheat you or induce you. No, take it, it's very easy. I'll never do that. You aram say, you think about yourself what you want to take. Is law good for you, or is, you want to do risk management, whatever it is. So take an informed choice. Blindly don't take 6D. But if you like law, whatever we are discussing, if you somehow find interest in it in the next 10-15 days, and then you may feel that okay, maybe then I can choose 60. It's up to you. Watch that video, it will help you. Yes, because many people have shifted from some other subject to 60 have suffered because they're not interested in law only. So if you have some interest in law, only then you should take, otherwise no point. But it is definitely scoring. This and risk management definitely scoring. Paper 60, they changed the structure also last attempt, because made it very difficult. This time also many people told it's difficult, but my people told it's chilled out because they knew what to. In an open book exam, it's very simple. You know what to open. You should know what to open. I'm not joking. Where it is. There are some 10 books. You should know where it is. That's all it is. 4 hours exam. So you just need to know where it is. So that's all. That if you figure out, no, done. Read the questions, 2 to 3 sheets it is, one question. So while reading the question, that also I have given how to read the question. Some 2-3 videos are there, and for my students I have given some 10-15 hours ka separate, case study based. So it's chilled out, guys. It's fun. I like 6D. It's very nice. I wish I had it elective when I was writing. I was not there. Anyway, so now history, coming to the history. Qualified. So if you see, one is this thing, right? If of the 6, if you file, gone. That was the scene now. Okay, this was the scene. People didn't give a damn. That's what I was saying. People didn't care about company law. They were not following this provision only. Here and there they used to file one and close it. Sometimes they used to do belated filing also and close it. Pay some money, pay some fine, close the issue. That was the scene. Now, in 2016, Modi came out with a scheme called income tax. Which one? Income disclosure scheme. Remember? Income disclosure scheme. In 2016, early it came. Arun Jaitley was the finance minister at that time. He came to Bangalore 2 times. Bangalore Palace, this palace grounds was there, no? He had a session there requesting people to disclose. They said 45% tax, 55% you keep. No questions asked. How, why, what, nothing will be asked. No prosecution, nothing. It's an income disclosure scheme, come and disclose. A Vada Pav fellow of Mumbai deposited 102 crores. A beggar, I told you, deposited 40 crores. A businessman in Gujarat deposited 686 crores. Correct? Beggar came, his income tax return never filed in his life. He is giving 40 crores. Arun Jaitley, bro, how did it come? Hey, no asking, cheating. What did you say? You will not ask. No asking. No questions asked. But in India, we are scared. We'll be like, if I go give what they don't know that I have, then they will do control S. What is control S? Save. Arun Jaitley asks 40 crores, control S. Oh, you are 356 crores, give me details, control S. Next time I'll see. I told you this time no prosecution. Next time I can do, no. I'll keep an eye on you. People scared. Fear, obviously, no. So though there is a scheme, in India, all those schemes, people were shocked. Oh, government is telling, come and give me money, no questions asked. How will I believe? I cannot believe all this. So almost 80% of the fellows didn't do it only. It was not like a very huge success, it was on flop show. Because in India, because first of all, that number of taxpayers percentage is only so less. On top of it, income disclosure scheme also, people didn't come forward. That was a thing to do, it was a master stroke. Once they gave an opportunity, nobody utilized the opportunity. And the end of the year, what happened? November 8th, no? November 8th. Mitro started. Correct? What happened? Demonetization. He said, I told you to give money. I was happily taking. Correct? Happily taking it. Told you to, give the money. But you didn't do anything. Right? So, now you do demonetization. Between November 8th, demonetization happened. Between November 8th to November sorry, December 31st, 2016, 30,000 crore rupees was deposited in some small companies which really did not have anything. These were all sham companies. They were just opened with no transactions whatsoever all these years. Suddenly, 10 crore, 2 crores, 5 crores. Correct? I had my friend who's a money lender. Money lender guy is in some other town. He called me. He's like, uh, I had lent money, people were not paying only. Now after demonetization, everybody is bringing sacks of old notes. Suddenly money came from them. So I had given out some 10-15 crores. Now they have all repaid with interest. 20 crores is there in my house. What to do? He sent a picture of also. He had cleared his room, bed, everything cleared. 20 crores. 20 crores, sorry, was in his room. What do I do? I said, do I have lighter? That's all. So if you see, then he came to Bangalore. In Bangalore, there are many chartered accountants, unfortunately, who will do all these things. Conversion, converting black to, I mean, all these things. That is, this is not black to white. This is what? Old black to new white. Correct? No, old black notes to new white notes. And they have a nexus with the bank manager. Demonetization was a huge failure because of the bank managers. Nexus. Politicians got crores and crores of notes, new notes. People like you and me had to stand in the queue and not get anything. 2,000, 3,000. Right? It was a failure because of the people, not because of the idea. The people or the people who had to execute were corrupt. As simple as that. From the police officers to the bank of officials, everybody. Not everybody, but a major percentage. We can't blame the good people at least. So a major chunk was like that. Anyway, so 30,000 crore. Arun Jaitley and Modi are sitting and saying, how is it possible? In 2 months, 30,000 crore suddenly. So my moneylender friend was a small guy, 20 crores. I am talking about 1,000, 2,000 crores there. 20 crores is what? Peanuts. He came to Bangalore, some very good CA, I don't want to name that CA, very famous CA in Bangalore. He helped in conversion. He took 20% cut. Correct? 20% cut. 4 crores in his pocket. Conversion rate. So like that, CAs only helped, unfortunately. That's why Modi told in the CA on CA day, there are some black sheep which is who are actually destroying your profession. Indirectly he told, right? So if you see, that is what happened. Now there is an interesting section. See, this is all the history. That's why this section came now. Now we have made it very stringent. So after this demonetization, what happened? Like this section was already there. 2013 was already there, no? Which had you have to file and all those things. That's okay. Now what happened was brilliant. Next was there's a section called 455. Check it out. 455. Let's see. Have you heard the concept of dormant company? Dormant. Four, five, five. Sorry? Companies already floated, correct, but no transactions, correct. So if you see my chart book, I don't know if you have got it today, but if you have the chart book also, there I have given that. One second, I'll show you. Not this. In the chart book, in the miscellaneous part. You've got it, huh? Anyway, I'll show you, it's fine. In page number miscellaneous 5. It's okay, you can see here only, no tension. What is a dormant company? Dormant company is of two types. One is inactive company. One question I'll ask you, can you start a dormant company? Or dormant company is which is already active, but now I don't want to do anything, so I'm converting it to dormant. Or can I start? Huh. Huh. Perfect. So if I have an idea for a business, because in India, all these brilliant people especially from IIT, so they do engineering in IIT, 20, 21-year-old kids, 19-year-old, suddenly when he was studying, idea struck him. So one lady is studying at age 20, idea struck her. Correct. So they will go and say, this is a brilliant idea. I'll give you an example. So there was this guy, correct, uh, in IIT, I think IIT Chennai or IIT Roorkee, I don't remember which IIT. So he want in 2000 sometime 2010ish or 2008 or something. So he was a young kid that time. So he just went out. Bhavesh Agarwal was his name. He just went in 2000, yeah, some 10, 15 years ago. He wanted to go for a party. He called a cab. That time they had to call a cab. So that cab company didn't come only. There is taxi agencies, no, he didn't come. So he got pissed off. So he just went back to his room and he said, what is this nonsense, man? I had to go to this party. One day I got a break and nothing has happened. So his other friend, they were learning Spanish. His other friend come and said, hey, hola, Bhavesh, what's up? Hola is hello in Spanish. This guy suddenly Googled, which is the biggest taxi company in the world. It was Uber. And he opened the balance sheet and tried to understand how many taxis did Uber own. Zero. You own zero taxis and you're the biggest taxi company in the world. Then he came to know the concept of cab aggregator. Means Uber is just a platform which will bring the customers to the taxi owners and taxi drivers. He said, I want to start this in India. He immediately went and registered that name also, Ola Cabs, as a young IIT fellow, because he wanted to complete his studies. He didn't want to leave college just like he didn't want to be a dropout. He wanted to leave. You have to finish the college and only then do it. So like that, youngsters in India. That's why Modi spoke about Make in India campaign. We have the power of the youth. We may be the second largest largest democracy and the second largest populated country in the world. Correct? After the first one, China. They are doing a good job eradicating population also, because they brought coronavirus, right? That's the thing. So they are doing that also. They are increasing their population, destroying the world's population, right? So if you see, that's the thing. Yeah. So there was a joke actually. To settle this entire dispute, India and China should play a cricket match. Correct? So Indian cricketers, Kohli and all that, and Chinese fellows. China doesn't have a team, I'm just saying. Should play a cricket bat. Still China will win. Why? Why? Because the Chinese will eat away all the bats. What will Virat Kohli bat with? God, no? That's the joke. Right? That's how it is. They will not leave that also. All bats gone. So if you see, still they will win only. Alright? So if you see, yeah. So basically you can definitely start. So they understood all these things. That time it was not there. So in 2013, the government decided that no, we have a youth here. We may be the largest populated democracy, but the youth percentage is crazy. And I want them to come here and work and not across the world. If you see across the world, the biggest companies, CEOs are people of Indian origin. We are inherently brilliant. I'm not joking. All of us are brilliant. I'm not saying brilliance has to come out in marks. Marks will not take us anywhere, I swear. Marks will not take us anywhere. If you are rank holder, but if you do not have the street smartness to survive in the world, it's a waste. But if you scored 400 out of 800 in CA, but you are street smart, you will be more successful than a rank holder. I'm not saying all rank holders, I'm just saying some people are just bookworms, only rank, they only want to study, but they don't have any street smartness to live in the world. It depends. There's a problem. So if you see, they said, no, I want to do something where the people will be, the youngsters will be given an opportunity to do something. That is why this wonderful concept came. Dormant company. You have an idea, go and register, patent it, IPR, intellectual property right. Then come to me and say, sir, I want to open a company which has to be inactive initially. I'll finish my studies, I'll get funding. That's what Ola Cabs, they got funding. I don't want anybody to copy this idea, because in India, no, today you will go somewhere and you will see, oh, this idea I had already thought of 2 years ago. Have you felt? I have felt so many times. But then my brains tell, boss, but you didn't execute. Everybody will think of ideas, but you need to execute. So that is a scene. Correct? So that's what. Now today, Ola, you can just book a cab, book an auto. Now they feel that because of Corona, the thing, people are okay with driving on their own. So Ola has come out with self-drive options. Basically, they'll give you the car, you can only drive. So all those options have come. Correct. Same thing happened in Bangalore also. This and in across India, people did not want to own cars, but they wanted to drive different cars. So Zoom car came. Wherever you want some 10-day self-drive, go. Like recently, I went couple of 2-3 months. I just came back in August. I had gone, not August. August was Corona. After that, sometime in November, I went to Gujarat. So I went there, Zoom car I had, and I traveled 15 days. I only drove across Gujarat. So if you see, it's very, who will take from here? So it's available. So what I'm saying is all these are Indian ideas, maybe borrowed from abroad, but they're Indian ideas executed in India. So that's why this wonderful concept, hold on to an IPR. If I want to hold on to an IPR, intellectual property right, or an asset, but I don't have any significant accounting transaction in the last 2 financial years, I can call myself, or I can register myself as a dormant company. I have an IPR, I have a company, but I'm not doing anything, so I can just go and tell, sir, I want to start off this company as a dormant company to hold on to an intellectual property right. Possible. Wonderful concept. Or if it's an inactive company. What is an inactive company? They have gone ahead and defined in 455. It is not carrying on any business or operations, okay? Or no significant accounting transaction from the last 2 financial years, okay? Then this dialogue, see. Not filed, that is the link. Annual returns plus financial statements for the last 2 financial years. In 2017, when the Modi government decided to analyze the companies which suddenly woke up during demonetization, where 30,000 crores were pumped in, they saw that none of those companies had ever filed annual accounts and annual returns. So next question Modi government asked was, boss, if you have not filed annual return and annual financial statements for 2 financial years only, you should register as an inactive company and make it dormant. And dormant company, there cannot be any significant accounting transaction. You have to deactivate and make it active company. You have not done anything. Aram se or depositing. So the government sent a show cause notice under section 248. So seeing this scene, are you guys understanding? Seeing this, whatever happened, dormant company, nothing had happened. No. So they sent a show cause notice under section 248, saying that all you companies, how many companies were there? Believe it or not, almost 1.5 lakh companies. 1.5 lakh companies, you have never filed anything in your life. Suddenly your accounting transaction one after the other you are doing 30,000 crore worth. So I am giving you a show cause notice under 248. Here only it's there. I'll show you. Let's see the section itself, it will be easier. 248 show cause notice will be given by whom? ROC. Where a registrar has reasonable cause to believe. Point number C. A company is not carrying on any business or operation for a period of 2 immediately preceding financial years and has not made any application within such period for obtaining the status of dormant company. They told him, you have not filed anything, which means you have to go for dormant company. Because if you have not filed for 2 years, immediately you have to go for dormant company. You have not gone. So you have not done dormant company and you are not carrying on any business. Suddenly money, how did it come? Show cause notice. And they said, he shall send a notice to the company and all the directors of the company of his intention to remove the name of the company from the register and requesting to send their representations. They said, this is it. Please send the representations, show cause notice, why I should not throw you out. Why I should not throw you out. So I'll show you. In 2017, guys, they gave SCN, show cause notices. Here, like this. So it's a public notice, is form number STK5. Yeah, the Ministry of Corporate Affairs has hosted its website, public notice STK5 for striking off of companies under 248. Companies have not commenced business, they are not carrying on any business for 2 financial years and they have not made any application. This notice has to go. This is one and this is one more. Yeah, see. See when 26th July 2000, this is after demonetization. 5-6 months they waited. See here. 7,399 companies. This was one list, that's all. Notice is hereby given, 7,399 companies, list enclosed. I am going to remove it. This is Karnataka only, 739 in Karnataka. Any person who wants to object, you can please come, he says, and see. Chamrajnagar Sri Chamrajeshwara Company Limited. Right? How many companies? Here, 7,399. Friends Union, it seems. Crazy. Nothing. Many of them are public companies also, not just private. Here, Shivabhadra Investments and Leasing Limited, public company. Like that, so many companies, guys. They gave us strike-off notice. Because these are the companies where money laundering had happened, that put money. Then what happened? They gave a defaulting company list. In that year only I had taken all these things. This was all taken that year only. See, list of defaulting companies. Defaulting in what? Annual returns and annual financial statements. You know what they did then? That was 2 years. They didn't give anything. Now it had become 3 years or more. Under 248, what did they do? Struck off the name. But they had to catch hold of the directors. So under 164, what did they do? You have not filed annual accounts and annual returns for 3 financial years. So disqualified. For how many years? 5 years. You have not filed for 3 financial years, so you are disqualified for 5 years. One question now is very simple. Are you disqualified in that company or are you disqualified in every company? Means I am a director who is a director in 10 companies. One company is caught like this. I am caught in one company like this. 9 companies are fine only. 9 companies have been filing the returns, fine. 9 companies, no tension. This company, problem. Will I be disqualified in all 10 companies or only in this company? All 10 or only in this? That interpretation did not even make sense. Why? Government deactivated their DIN. If your DIN is deactivated, where you will be appointed? How many directors went like that? 1.5 lakh directors. Actually happened. That time only I wanted to open the, see this list I have taken. This is one list. Sin, company name, Ragoji Cement, status active, DIN of Meena Serau, status disqualified. Why? Violation of 164 2A. Period from how many years disqualified? 1/1/2016 to 31st/10/2021. 5 years. This is one list like this. This is 635 pages, one list. Here, 635 pages. Like that, then institute, I mean the MCA gave Excel sheet also. Take, do whatever you want. Excel sheet also I'll give. This I had downloaded that time only. Here also, you can give filter option also they gave. You do whatever you want. Sin, company name, incorporation date, company category, company class, subcategory, everything. Location, financial year, filing flag, both AR and BS not filed, registered address, authorized capital, paid up capital, everything they gave details like this. And they gave a order. In the order, see this is the list, disqualified directors list. So that list also was, allowed, was shown, all this list like this. That time only I had taken. Then if you see defaulting companies also, see how many, this I showed you already. Yeah, so like that full thing came. And list of struck off companies, this also was the list that time. ROC Ahmedabad was 12,000, Bangalore 22,000, Chennai they also don't know, Chandigarh, Chhattisgarh, Coimbatore, Cuttack, Ernakulam, Hyderabad they don't know, Kashmir, Kolkata, Mumbai 71,530 companies struck off. Crazy. Delhi 53,000, ours is 22,000. Happened. Then in the news also, obviously this was a newspaper clipping. On 12th September, MCA that identified 1,06,000, and it became almost 1.5 lakhs. And they did not file their financial statements. Shell companies, though not defined under Companies Act, are those which adhere to basic company laws and are used to avoid taxes and convert black to white. Shell companies they are called. The names include, the director's name includes some prominent politicians from Arunachal Pradesh to Tamil Nadu and businessmen including non-resident. This is possibly the first kind of naming and shaming exercise, they say. Naming and shaming. So this all came in the news, this also. Bank accounts of 2,09,032 suspected shell companies have been frozen. These are all taken in 2017 only. I knew that this is going to be big, so I collected it that time only. This was what happened, guys. This is the history. So in 2017, you will be disqualified. When I deactivate the DIN, you will obviously go in which companies? All companies. So vacation of director was, and not only, see, disqualification at the time of reappointment. So can you continue in those companies? No. So in 2017, both 164 and 167 were invoked. Correct? After this, what happened? That's what. So this 164 and 167 were invoked. And how many? Almost 2 lakh plus companies were struck off and 1.5 lakh directors DIN deactivated. I showed you one thing which spoke about what? I showed you a PDF which said 1/11/2016 to 31st October 21, if you remember. Which means he has not filed from which year, guys? 13, 14, 14, 15, 15, 16. Because that 16 wala, you should have done it by October. AGM would have been held sometime, whatever. Didn't do. So it was struck off. Now the lawyers of those 1.5 lakh lawyers, what did they prove? That directors vacated from the office where directors should vacate from the office where they committed the default, and not all companies. They wanted to prove that. Correct? Should they vacate in all the companies or only in the companies in which they committed default? Vacation of office is from which company? If you see, that's what. So the lawyers saw the law now. The lawyers saw the law. You leave this thing, only this you read. I asked you a question, no? If you have committed disqualification after you become a director, can you continue or will you vacate the office? That link is given in 167. In 167 1A, the office of a director shall become vacant in case he incurs any of the disqualifications specified in section 164. Don't read the proviso, it will confuse you. Only this is enough. The office of a director shall become vacant in case he incurs any of the disqualifications in 164. Office of a director shall become vacant. Which office? Defaulting company office, non-defaulting company office, or all offices? Without reading proviso. Proviso will confuse you. That came later. Don't read. Only this line, 1A. Office of a director shall become vacant if he incurs any of the disqualifications. Office of which director? Director of his directorship in all companies, or his directorship only in the defaulting company where disqualification has arisen? When you read that properly, what will you understand? The office of a director shall become vacant if he incurs any of the disqualification in 164. All companies or that company in which he is disqualified. Office of a director. So this was interpreted to be, and the correct interpretation also, to be the defaulting office only. Defaulting office only. For example, that call money. Call money I didn't pay in company A, I paid in company B. Why should I vacate in company A if I am already a director? I will not vacate. At the time of buying the shares, 1 month was over, I have not paid the call money. Can I be a director? Yes, because 6 months has not passed. I became a director. Now 6 months has passed. Am I not disqualified? Yes. Will I vacate my office? Yes. In which company? Obviously in that company. The office of a director shall become vacant in case he incurs any of the disqualification in that particular company. Which office will be vacant? That office will go vacant. Which one? But the thing is, in DIN case, they deactivate. That's what I'm saying. So when the government deactivated the DIN, lawyer said that is wrong. Lawyer said you cannot deactivate the DIN. I have followed all the DIN provisions properly. You are combining this disqualification, this not filing part to the DIN part and deactivating the DIN. You are wrong. That's what the lawyers proved. Lawyers of which lawyers? The directors' lawyers. They said government what they did was wrong. They said you should have disqualified only in that particular company, not in all the companies in which he is a director. Why are you taking away his means of livelihood? Was this a very sound argument? Actually, no. It was like dicey. They said, no, he's cheated. He has cheated in one company. What is the guarantee he won't cheat in the other remaining 10 companies? But lawyers caught one brilliant point. One brilliant point. What is that? When they were playing around with this, no? Lawyers and government, jugalbandi. Lawyers tried, almost proved this. What was the proof? You should only do in which company? The defaulting company. Other companies you should not do. Government says, you are challenging the law. What will I do? Change the law. They added a proviso. Brilliant. This is all Arun Jaitley's brilliance, guys. We lost a very, it's not about BJP Congress, I don't care. We lost a very good legislator. Brilliant he is. Arun Jaitley. Passed away, no? Very brilliant. We lost a very good, very smart, very brilliant. In IBC, I'll tell you more about it. You see that? This they added when this kirik was happening, they added off slowly when? Companies Amendment Act 2017. 7th May 2018. When the cases were going on, they inserted this. Provided where he incurs disqualification under subsection 2 of 164, which is which one? This filing only. The office of director shall become vacant in all companies. Other than the company which is in default, full ulta they did. That company is default, you die there, I don't care. Other companies get out. Did the lawyers get anything out of this now? Gone. Case closed. Right? This was the amendment. This is the reason why the amendment came. In other companies, you get out. This company you stay. This is only for which one? 164(2). For other things, ulta. For call money, ulta. What? That company get out. Other companies stay. But 164, because the lawyers were about to prove, they changed the law. Added this section, sub proviso. So gone. Then lawyers, they are also brilliant, man. They are not just, because lawmakers are also lawyers, chartered accountants. And these people who argue for the other people are also lawyers, chartered accountants, company secretaries and all, CMAs. So if you see, they told one thing. When did the new act come? 2013. It came from 1st April 2014. Which means 164(2) came from 1st April 2014. Which means, which 3 financial years should you see? You should see 14-15, 15-16, 16-17. Correct, no? 2013-14 you have seen. This comes under the old law. And under the old law, what was the scene? Even if you file 1 out of 6, you are fine. And he had already filed 1 in this. In the old law, this was problem, no problem. No problem. In the new law, this is problem, no problem. Problem. So you are telling what is not a problem in the old law. You are creating a problem as a new law. So you know what the lawyer said? This is unconstitutional, they said. If the government had waited for 1 more year, no, they could have actually thrown out everybody. But government also did it off here only. If they had waited for 16-17, do you think people would have still filed in 1 year? No. But government wanted to crack down on all these nonsense sham companies that are happening. So first was income disclosure scheme, then immediately this happened, demonetization. Then in 2017, all these things happened. And the case started in 2018, they changed the law in 2018, I showed you. But still this point was valid. 2 high courts supported this decision. One is Gujarat, other one is Karnataka. High court decision came which said, directors, though they are wrong, 13-14 making it is unconstitutional. These directors were smart. 16-17, everything they filed. Annual accounts, annual returns, what you want, take. Everything they filed. So this year there was a problem, this year there was a problem, this year there was no problem. 13-14 was a problem as per 2013, but no problem as per 1956 Act. Based on this point only, they argued, and Gujarat and Karnataka High Court decision, they said it is not so. So if you see, these are all the Gujarat decision. See, High Court notice to government disqualification. The Delhi High Court has issued notice to MCA and ROC on petition challenging the disqualification. This is one part. The Delhi High Court said, then Gujarat High Court gave the thing. Advocate Manish Jain, counsel for the petitioner, challenged the wires, Latin for powers, ultra wires, powers of section 1. They said the section was wholly ambiguous, it was not clear and all that he told. See, the section is unconstitutional. And if you see, this is the Karnataka High Court. Disqualification of directors under 164(2)(a) for default before April 1st is illegal. That is what they say. The continuous period of 3 financial years must commence with effect from 1/4/14 onwards. No period prior to 1/4/14 can be taken into consideration to be part of the continuous period of 3 financial years. 3 financial years should be taken in a different way. 3 financial years should be taken in a different way. The correct way is this. Thereby, impact of a director of a defaulting private company, this is what they said. Disposing of a batch of nearly 300 writ petitions. High Court said that you cannot take this into consideration. All these things. Continuous period, they said. Then also one more thing. 164(2) was not applicable to private companies in 1956. But 164(2) is very much applicable to private companies in 2013. So that time they did not have to follow it only. Now why are you crying? So as far as directors of private companies are concerned, a provision like 164 is applicable for the first time. Thus no period antecedent, means before 1/4/2014, could be taken into consideration where there has been a default. This is because prior to enforcement of the Act, disqualification was not imposed only for director of a private company. So as far as directors of private company are concerned, definitely no tension. For public companies also, if they have filed at least one that time, no problem. Public companies also same thing. Though there is a disqualification, the consequence was not to the extent stipulated under 2013. That we know what they are trying to tell, we know now. This was the wonderful decision by Karnataka High Court. The Delhi High Court also gave a stay order and all that. Then Gujarat High Court also, I told it before, then Karnataka High Court told now. So if you see, ultimately what happened? So after this point, what happened, guys? 8th one was what? 7th May 2018 amendment. 167(1) proviso. Proviso was inserted. Correct? Because why? After lawyers demanded that after lawyers proved that the directors should vacate from, this amendment came why? Amendment came because lawyers representing the disqualified directors had done what? Tried proving that directors could continue in non-defaulting companies. Directors could continue in non-defaulting companies. Then ninth, Gujarat and Karnataka High Court. Gujarat and Karnataka High Court, what did they do? Deemed disqualification in 2013-14 as illegal and what? Unconstitutional. Illegal and unconstitutional. Are you guys understanding? This history will never be asked in the exam. But if you don't know the history, you will forget the provision. After the history, you will never forget the provision. You will know exactly what it is now. You will never get confused. So that is how we need to know the history of every section as much as possible. Gujarat and Karnataka High Court deemed disqualification in 2013-14 as illegal and unconstitutional. But this menace of these bloody sham companies were still there. If you have watched the movie Wolf of Wall Street, you watched Leonardo DiCaprio. It's actually a real story of a guy who used to scam people. How? These brokers just call up and say, this is the best company to invest in, please invest. People just blindly do, no? Or you watch this scam 1992, Harshad Mehta. Right? There also, he just called up, this is a very good company, you invest. But then he did a different type of scam. But this Wolf of Wall Street, he used to take these small companies called penny stocks. The registered office was a toilet. Registered office was a shed. He gave super build up to the people when he was talking. No, this is the best company in the world. You should invest. That's the thing. This thing, that thing. People used to fall for it. So he made a killing out of it. So when government decided to verify all these things, they saw that one company's address was a public toilet. Public toilet, first floor. In public toilet, ground floor was there. First floor was not there. Basically like that. Office only is not there. Some shed, some other normal dilapidated house, like that address they were giving. So in 2019-20, new concept has come. What is that? Now, to curb the menace of what? Sham companies. To curb the menace of sham companies. What has come? Concept of active tagging. Active tagging. Active. So it is active company tagging identity and verification. So active full form is active company tagging identity and verification. What tagging you should do? The geo link. Geo link means what? The actual geographical position link has to be sent to the government. How? On Google you should go and get the actual geo link. You will get know that which degree, 109 degree, latitude, longitude, that you have to give. That is called geo tagging. Second, you need to take a picture of the facade of the building with the board on it. Then you have to take selfie. Company secretary will take selfie. I am here only. CEO will take selfie. Office pictures and all you should post. If you still want to fake it, you can get it Photoshop. That's okay, but at least something will reduce. No, your geolocation will come. Then the next part is they inserted 448 section and they said chartered accountant, company secretary, you go verify. I will not do it. So a declaration has to be filed by a chartered accountant or company secretary who is incorporating. I so and so CACS have verified the address, personally gone. All that you have to do. Verification is a must. Otherwise, he will be charged for wrong certification. I showed you that Nagappan Swarnalata case. That fellow didn't see only, he just signed it off. So if you see, these are very, very important things has to be done. Active tagging they have introduced. These are the effect, things to curb. So this point number 10 is nothing but steps to curb, steps to what? Reduce the sham company menace. Menace means problem. So to step to reduce, one is active tagging. Definitely active tagging. Then 2-3 points, then we'll stop. Next is what, guys? They have introduced the concept of layers. Layers. This is in 186(1) and 2 clause 87. 2 clause 87 is subsidiary company. 186(1) is investment company. One is subsidiary company, one is investment company. What is that, guys? This, just a quick thing. There was a company called Rendezvous Sports Private Limited. This Rendezvous Sports Private Limited built a IPL company team called Kochi Tuskers, if you remember. It played for some 1 year, that's it. Suddenly they came. This was with the blessing of the then Member of Parliament, Dr. Shashi Tharoor. You have heard Shashi Tharoor? First of all, you should understand what he speaks. Correct? So, Dr. Shashi Tharoor, Rendezvous Sports Private Limited, this is what happened. Kochi Tuskers. So then he was the MP, and on the board of directors there was a lady called Dr. Sunanda Pushkar. She got some 100 million worth of shares, just like that, and she was made a director. So when they did the investigation, why does she deserve? She doesn't even know anything about cricket or management, nothing. She was only there because she was the wife of Dr. Shashi Tharoor. These are the allegations. And between Rendezvous Sports Private Limited and Dr. Shashi Tharoor, there were almost around 400 to 500 intricate sham companies. And the money and the kickback reached that Shashi Tharoor. These are the allegations against, the thing. The only person who knew the entire deal was Sunanda Pushkar. And Sunanda Pushkar was found mysteriously dead in Taj Hotel in a room where in Delhi, I think, where she committed suicide, apparently. And there was poison in her body. So there are two allegations against Shashi Tharoor. One is the murder investigation, still going on. Or is it a suicide? That's still going on. And this one, this allegation of sham companies, going through various sham companies. To curb this thing, they told in 186, we'll discuss that when we reach 186.1. There can be only some layers, 2 layers, that's it. If you want to invest, it should only be through 2 layers. And a holding company can only have 2 subsidiaries, S1, S2, that's it. This is what they came out. This is to reduce the menace of sham companies. More on that when we discuss 186.1 and all that layer. That will be discussed later, guys. It will be discussed later, but still, just to give you an example. Then lastly, this active tagging, no? in section 248. Last part. This two were added. A new section 10A was introduced and 12 was amended. They say that when you are filing the incorporation certificate, you need to give a declaration under 10A. There is a new section. Commencement of business, 10A. Brand new section. When did it come? 2nd November 2018. So you need to give a declaration within 180 days that every subscriber has paid the value of the shares properly, and also you should tell that the office is properly located, verification is done properly, all those things have to be done. So that is why they have amended 248 also to insert this. You have to commence your business properly and physical verification has to happen. This is 10A and 12. That's why 248 1D and 1E have been inserted. And if I come to know that you have opened a sham company, no physical verification, dummy shareholders, no shares have been issued, then I am going to strike off. So 248 1D and 1E are also introduced. 248 1D and 1E. Lastly, 248 1D and 1E. Last but not the least, you would have heard this fresh start scheme. Have you heard? Companies Fresh Start Scheme, CFSS, came in 2020. Companies Fresh Start Scheme. So what did they say in that? They said if you have not filed any of the previous documents etc. which had to be filed till 2019, it's a one-time window. In 2020, file everything, there will be no prosecution. But one thing you tell me, if you have defaulted in filing the annual accounts, annual returns, that you can file, okay, that's okay. But will it take away the disqualification? Is this fresh start scheme immunity for disqualification also? Answer is no. It is only for filing defaults. If you have not filed certain things, you will file now. That is the scheme. Fresh start scheme, it will not take away the disqualification. So it comes to the last part to close the loop, after which we can take a break. Case number 4 in page 46. Did you understand the history? Yes or no? Yes, great. Alright, so if you see here, last part before the break, financial statement filed, not filed, problem. Financial statement not filed, annual returns filed, problem. Now the thing is here, this one. Financial statement not filed, annual returns not filed on due date. Annual returns not filed on due date. Immediately what they did a belated filing, both quickly. Next day only. Ideally, if you don't file both, there is a problem, I agree. But by filing belatedly, it appears they have made it a no problem situation. The question is very simple. Will belated filing, if I file it little later, it will cure the defect for sure. But will it cure the disqualification? Will it or will it not? If I file certain documents belatedly by paying the requisite fine, will it take away the disqualification? If you say yes, every company will do it. What is better? Disqualified for 5 years or paying 1 lakh fine? Paying 1 lakh fine. I'll make that 1 lakh aram se anyway. That's why. So that's what I told now. Everybody can pay fine. Paying 1 lakh is better, no? They'll make up that 1 lakh anyway. So can I allow like that? No. So what did the government say? Nothing doing. Belated filing, you will still remain disqualified. You will still remain disqualified. Here you see page number 47 here. Can the default be subsequently rectified? Even when the default is subsequently cured, how is the default cured? By belated filing. The disqualification shall remain. Right? Page number 47. Are you getting it? Second point. Once defaulted, subsequent rectification is of no consequence. So the last dialogue. Belated filing will cure the defect. Belated filing will cure the defect, but not disqualification. Belated filing will cure the defect, but not disqualification. Belated filing will cure the defect, but not the disqualification. Got it? So no, clear? This is the full history of 164 2A. 2B still not done. 2B is okay, easy. 2A was lot of things were there. So always remember, knowledge of the past is guidance for the future. So though the link was not given anywhere, constant reading and analysis will help us link it. So slowly, when I can do it, you can also do it. So now please start reading the newspapers and please start following the news. Slowly you will be able to connect everything. 4 years later it will strike, oh, I read that there, now everything is connected. Like that. Okay. Online friends, it will become no problem, but subsequently that. So no, third year is not a problem. Third year also becomes a problem. No problem as far as filing is concerned. Yes. Fourth year, this third year, no problem only for filing, as far as filing is concerned only. But will it take away the disqualification? No. It will cure the defect. What is the defect? Not filing. Defect will be cured. But will it take away the disqualification? No. It will not take away the disqualification. Like that, I can cure previous defects also. I can file belatedly. So, without paying some little extra fine. This is nothing but again the company's fresh start scheme has reduced that fine also. And all the other filings which you should have done, you have not filed, okay, you file it off now. But they also have told it will not cure the disqualification. You will be disqualified. Rather than paying so much fine, I am reducing the fine. Fine is reduced. In this fresh start scheme, this is gone now almost. I think December 20 or something it was there, gone now. Alright guys, on that note, we'll take a break. Online people, did you understand? Yeah, so that is about it. We have finished 164 2A. Now after the break, we'll do 2B. 2B is a little chilled out, but 2A had a lot of history. That's how it is. Okay, let's take a break. We'll get back after the break. All right. Let's now go, guys. 164 2A. 2A. 2A done. 2B. Which book? Q&A is always online, man, because that is how it is done. Let's see what can be done. Q&A is always, you can take a print if you want. I'll give you it's always released on my Telegram channel, because book is separately available, that if you want you can purchase, but you guys, there's no need. Use the online thing only, and if you want to take a printout of the relevant pages. People sell that for some 2000 rupees and all that. For us, I think it's some 400, 500 rupees, but that's the printing cost. But then what I did was last time on Telegram, I released it off, so that all students can use. It's always like that. So you take a printout if you want to, no problem. But printout is not needed. Why do you need printout? You can just browse through the answers now, because anyway you have to write the answers. So you can browse through those answers. It's your wish. If you are comfortable, then you can take a print. That will be given. I'll release it on my Telegram channel only. 164 2B now. It's here only. We are done 2A. Now we'll see 2B. So again you have to read it like this only. No person who is or has been a director of a company which, now B, has failed to repay the deposits accepted by it, or pay interest thereon, or to redeem any debentures on the due date, or pay interest due thereon, or pay any dividend declared, and such failure to pay or redeem continues for 1 year or more, shall be eligible to be, so no person shall be eligible, means the person shall not be eligible to be reappointed as a director of that company or appointed another company for a period of 5 years from the date on which the said company fails to do so. Now, 164 2B talks about triple D points: dividend, deposits, debentures. Dividend, deposit, debenture. Triple D. Fail to repay the deposits accepted by it, or pay interest thereon, to redeem any debentures on the due date, or pay interest thereon, or pay any dividend declared. Dividend, deposit, debenture. And it says fail to pay. First of all, dividend, if I come here, dividend and failure to pay. If I talk about dividend, we saw the definition of dividend. What does it say? Remember that day we saw? Dividend includes interim dividend. That was the definition. 1 second. So 230, 231 and 235. So debenture is defined in, you can see, 1 second. Debenture is defined in 230, deposit 231, dividend 235. Let's stick to the dividend now. Dividend includes any interim dividend, which means there can be two types of dividend, no? Final dividend and interim dividend. So when I say dividend, you have final dividend, interim dividend. Interim dividend is paid when, guys? In between two AGMs. It is given interim, correct. Final dividend is paid at the AGM. Who will recommend and who will declare? Interim? Both. Who will recommend, who will declare? Board of directors. Okay, who will recommend final dividend? Board of directors will recommend. Shareholders won't recommend. Who will recommend? And in interim dividend, both will recommend. Board. Right. So let's see the interim board only they say. Okay. So if you see this board, this thing, recommendation, etc., generally is given in 134. If you see 134 3K, this is the board report. In the board report, there shall be attached to every statement a report by the board. In that 3K, amount, if any, which is recommended should be part by way of dividend. So if you see this particular thing, recommendation will be done by the board of directors. 134 3K. Declaration. Declaration will be done what? Shareholders. Yes. In which section? If you remember that adda points. Correct. There only it's given. We have seen there already adda points 102. Those adda points, there only it says. 102. Statement setting on the material facts, there. Here 102.2. In case of annual general meeting, all business to be transacted, here declaration of dividend. So dividend declaration here done by shareholders. 102.2A2. Shareholders will tell, if you don't declare dividend, you will get 2A2. Kannada. 2A2. Yes. 102.2A2. Recommend 134 3K. Section number and all just to show off. So don't worry. Yes. On the other hand, interim dividend will be both, as you said, recommended and declared by shareholders. Sorry, recommended and declared by board. This is 123.3. We will see that also. 123.3. The board of directors of the company may declare interim dividend. May declare over. There only it says, no. So it is 123.3. BOD. Final dividend, recommending, declare. Interim dividend, recommendation, declare. This is the scene. It will be done by whom? The board of directors here. Interim dividend will be paid between the AGMs. That's how it is. Dividend again is return on capital, as simple as that. Now the question is, this is one part. As we have seen now, if I take the structure, in the board of directors report, what happens? Now one question, guys, just to link it, dividend includes interim dividend, no? Fine. Declaration of dividend should be done by shareholders in the AGM, which means they have to pass a resolution. They have to pass an ordinary resolution saying that, okay, I agree to this. My question is, For interim dividend also should they do? Board has already passed. What I am saying is during the year, let's say I am sitting in the AGM now, 6 months ago the board has already given me interim dividend, which they can declare. They have declared. Today, what happens at the AGM? Declaration of dividend. So declaration, shareholders will declare. That is the final dividend you leave. But should they declare interim dividend also, because dividend includes interim dividend as per definition? Includes. So dividend, when I am declaring dividend, not only should I approve or declare final, should I also declare interim, because dividend includes interim dividend. Huh. 123.3 says I have to declare. That's okay. The board will declare. But should shareholders also, for administrative purpose, say, okay, I've already received it during the year, thank you, I approve? They can't disapprove. Shareholders will not like, why did you pay? I don't want. No shareholder will tell that. But what I'm saying is it good secretarial practice to also include interim dividend while declaring final dividend? Because dividend includes interim dividend. If you see the notices and AGMs of good companies, no, you will see it is good secretarial practice to include it. I'll just show you one. This is just a discussion that you need to know, that it is good secretarial practice to add into it. It's very good if you do it. Otherwise, it will be not a very good way of doing things. I'll just show you Infosys, because I feel Infosys, they really do their stuff really well. But they will not use the word declaration. You see here. To declare a final dividend of 29.50 per equity share, amounting to 14 point share. Okay, that's okay. And to approve the interim dividend per equity share already paid during the year. This is given why? Because of 235, dividend includes interim dividend. But they have not used the word declare, they have used the word approve. Will they disapprove and refund and all? No shareholder will do. In India, that too. I've already paid so much per share. Now you're saying, no, I don't want. No, I can't take it from you. No. So that is the scene. This is very, very good secretarial practice, because dividend includes interim dividend and you have to declare dividend. But board of directors have already declared dividend, but you just take it on record. So these are the ways that we need to interpret the law. So this is very, very good way of interpreting. Right? That is one extra point I wanted to tell you. Then coming back to this, these are small hidden points in law. Anyway, board of directors report will be recommending the dividend. In AGM you will declare dividend. Once you declare dividend, when should you pay it? CA enter. Within how many days? 30 days from declaration you need to pay. You need to pay within 30 days. What happened? Within 30 days you need to pay. But within 5 days from declaration, you need to transfer to a separate bank account for disbursement. And within 30 days from declaration, you need to pay dividend. If within 30 days it is not paid, within 7 days from the expiry of 30 days, you have to transfer to a separate account called unpaid dividend account. Unpaid dividend account. And it should remain in the unpaid dividend account for 7 years. After which you will transfer to the Investor Education Protection Fund of the government. Investor Education Protection Fund. Now my question is very simple. The Act uses the word failure to pay dividend. Correct, no? 164 2B says failure to pay dividend. My question is, what do you mean by failure to pay? If I fail to transfer to special account, is that failure to pay? If I fail to pay within 30 days, is it failure to pay? If I fail to transfer to unpaid dividend account, is it failure to pay? Or if I fail to transfer to IEPF, is it failure to pay? What do you mean by in this dialogue here? Fail to pay any dividend means what? Read fully, you will get the answer. Is it failure to transfer to separate bank account, or failure to pay after declaration within 30 days, failure to transfer to unpaid dividend account within 7 days after 30 days, or failure to transfer to IEPF after 7 years? What do you mean by failure to pay? 30 days? Why? First is transfer to, then 30 days you have to pay. 30 days you have to pay. So if you see there, failure to pay any dividend declared, very clearly they have given. Failure to pay any dividend declared means what? You have declared within 30 days you have to pay. If within 30 days you don't pay, you need to, then only this thing happens. And you see, such failure to pay or redeem continues for 1 year or more. This section will only apply when? That failure to pay will continue for how many years? 1 year or more. It is 1 year or more. So guys, here that's the structure that we have already written. Failure to pay only means failed to pay within 30 days of declaration. Failure to pay within 30 days of declaration. That is the meaning of failure to pay. This is the full structure. Any doubts? This is a dividend scene. This will help you in auditing also. Next. So it says what? Deposit, debentures and interest thereon also. And guys, here this very thing continues for one year. Means in 164 2B, the default is not paying. What is the default? Continuing for 1 year. In 164 2A, the moment you don't file, over, that's it. In 164 2B, I didn't pay, okay, it's okay. But you didn't pay for 1 year, the negligence for that 1 year, that's why I am going to punish you. That is the reason why this section is split into 2A and 2B. If the section that 1 year or more is not there means there was no need only, no? I could have had one section only. If you have failed to if you have not, filed annual accounts, annual returns for 3 continuous years, and also if you have not failed to pay dividend, debentures and deposits and interest thereon, over. So from the due date itself, disqualified. But here no, what they're saying, okay, you didn't pay, that date of default was in 2020, no problem. 20 to 21, one more year I'll give. Make good the default. If you don't make good the default, then only I am going to, do it. And here also, no, for example, if you don't pay and all those things in 30 days, then 18% interest will come as per section 123. You have to pay 18% interest. All that is separate. And also it will result in disqualification. That's the best part. Not only interest, but also disqualification. So if you go to this 123, 124, 125, all those things will give you the penal provisions. Anyway. Interest thereon also is what they say, interest as well. So for example, at 18% interest I told you, dividend was supposed to be paid, okay, the 30th September 2020 was your dividend declaration in 1 month. So by 31st October it should have been paid. So from 31st October it is not paid. So from this day 18% interest comes. Now the question is, the amount is around 10 crore and then 18% interest, 1.8 crore interest. 1 year or more, 2021 October. Now tell me, by 2021 October, they have repaid this full dividend, no tension. They have not paid this interest portion that they said will pay soon. On October 2021, will the director be disqualified? Yes or no? Interest not paid, principal paid. Principal is what? 10 crore. Will the director be disqualified? Yes, no. Interest if you don't pay. Disqualified or qualified? Online. Answer guys. Disqualified or not? No. Why? Yes, you see. Correct. Pay deposit or interest thereon. Debentures or interest thereon. Dividend or interest thereon, not there. Deposits was 10 crore. Interest was 1.8 crore. Due date over. Within 1 year, I repay the full deposit 10 crore. But I don't pay the interest 1.8 crore. Am I disqualified? Yes. But when it comes to dividend, no. Interest covered. Interest covered. Interest on dividend not covered. Now you need to tell me why. Online, good morning. Nobody is responding here. You need to answer, guys. They'll aram se be sleeping in the blanket. Christmas and all done. Sorry? Deposit and debenture are compulsory interest. Dividend also compulsory interest is there, 18%. Huh? Okay, generally like that you're telling, okay. Dividend is not a compulsion, okay. If you see the wordings, deposit and debenture, you will repay or you will pay? Repay. So as he said, when you have taken some money in the form of deposit and debenture, you are a company, you are bound to repay it along with interest. That's why they have used the word failed to repay. But dividend is not a compulsion, as I said. If the company feels like paying, they can pay. They don't feel like paying, no need to pay. Have they paid now? Here, failure to pay. They have not used the word failure to repay. They have used the word failure to pay. Failure to repay is what? Deposits and debentures. And in 1956 Act, in 1956 Act, in 1956 what was the scene? Actually, interest on deposits only was covered. Interest on debenture was not there only. Interest on debenture was not there, only interest on deposit. Why? Because in 1956 Act, this particular section, for debentures, always the company will have security. I mean, the debenture holders will take security in the form of assets. It will be secured debentures. So, in case you don't pay interest, the debenture holders will invoke, we will sell off the assets and recover the interest and the principal. So, interest on debentures was not covered. But deposit holders, there is nothing, very few secured deposits are there. It's always unsecured. So, for them, interest on deposits was covered. But now they said nothing doing will cover for both interest on deposits and interest on debentures. Interest on dividend, however, is not there. It can never be there because, as I said, it's not a compulsion. Only if you fail, only then interest will come. And there are other provisions in 123, 124 which makes the directors personally liable and all, it's there later. And if you declare and then don't pay, it amounts to fraud. You are actually, committing fraud. You have promised something to shareholders and then you are not paying. So, penal provisions are anyway there. They will anyway be thrown out separately. So, if you see, that's the reason why they say continues for 1 year or more. That is the scene. What about I have taken a loan, interest on loan? It should continue for 1 year or more, mind you. Interest on loan? Which brings me to the next question. Is loan a debenture? So, see the definition 230, 231. All these are asked in the exam, by the way. See debenture definition. Debenture includes debenture stock, bonds or any other instrument of a company evidencing a debt. Debenture includes debenture stock, bond or any other instrument of a company evidencing a debt. Does it include loan? If you see, generally debentures will not include loan and all. Loan is a separate thing. For debenture you will give instruments with interest rate. This still there is no confusion, it's okay, no problem. And it says some other futures in other things that later we'll see, that will not be considered as debentures. But you see deposit. Deposit includes any receipt of money by way of deposit or loan in any other form. Loan is not a debenture, but is loan a deposit? Yes. So interest on loan, is it covered? It appears so. But but does not include such categories of amount as may be prescribed in consultation with RBI. Does not include such categories of amount as prescribed in consultation with the Reserve Bank of India. Means what? RBI and government have prescribed certain things, and in those certain things they say if there is any secured loan which banks and financial institutions have given, that will not be considered as deposit, though it is very much defined under deposit. So now very simple, if term loans, in the exam they have given this, that's why. In the exam if they give the word term loans who will give? Money lender will give? No, banks. In the exam they have given so many times. Term loans, interest on term loans not paid for 2 years, they'll give. Disqualified, qualified? Qualified, because interest on term loan is nothing but given by bank, and bank is a secured loan. Secured loan is not a deposit as per the rules. Secured loan is not a deposit as per the rules. Loan given by money lender, I'm just saying, on money lender, random money lender gives an unsecured loan, that one 100% it's a deposit. That's a deposit. Got it? So this is a very important question. They keep asking interest on term loans. So term loans cannot be taken into account. Why? Debenture is not that at all, no. Debenture is something that is where you give as an instrument. You actually give the bonds, you actually give the instrument there. That is definitely not there. Debenture is very clear. What is not clear is deposit. When? Which one? Everything, even in loan you create charge, no? So whenever you create a charge, that has got nothing to do with whether it's a deposit or a debenture or a loan. So charge is nothing but your right over the asset, that's all. That can happen via debentures also, that can happen via loan also. So that has got nothing to do with anything else. So if you see, that's what it says. Reason to be written in section 231, yes. So what will you say? When they ask in the exam, interest on term loan, you have to say interest on term loan is not covered under 164(2)(b) because term loans are not deposits. Because as per 231, deposit includes any receipt of money or loan, but specifically MCA has excluded secured loan from the ambit of deposit. Since it is not a deposit, interest on term loan will not come. So look out for this interest on term loan or interest on loan. If they give unsecured loan and all specifically, then you have to treat it as a deposit. Clear? All this is done. Tell me. Tell me. Huh. Where? Huh. Correct. Huh. No, because loan is not a, her question was, even if the word includes was there, I'll just show you, so that for the benefit of even my online buddies, the question was, deposit includes any receipt of money by way of deposit. That's all is given. This is not given. Assume this line is not given. Only this much is given. So can you take it as a loan? So that again goes for interpretation. So some people may say yes, it includes, some people say no, it will not include. So two people will help. One will be MCA by giving out certain guidelines like this only. Does not include such categories as may be prescribed. So they may give certain categories which are not applicable. Or it will go for litigation. In litigation all these things will come, whether it includes, doesn't include and all that. They have given here loan in any other form. If this line was not there, ideally you should not include, because loan can never be treated as a deposit actually. A loan is not a deposit at all, because deposit has certain rules. Loan doesn't have any rules. Loan is governed by the agreement. So it's purely a contract between two parties, but a deposit is not a contract between two parties. It's more a regulation given by government. So because you have to have deposit insurance and all those things. So for loan and all, if you take deposit insurance, gone. So that's the thing. Correct. I got it. So generally you have to see what it means. Generally, like when you use the word deposit, generally, will you think of it as a loan? Is loan a deposit? Generally, no. Because general meaning of deposit is something that you give and you will get a receipt for that, and you have deposited money and for that some interest you will be getting. Whereas loan is a different thing. Loan is you actually can give in cash or kind also. Can I loan you my Activa? Yeah. But in deposit it's only cash, no? Right? So by seeing the features you can see. I am only including it because they have given this here. If they have not given there, yeah. So generally loan cannot be treated as a deposit. But if this line was not there, it would have been open to many litigation, and it will again go to all these things. So if you see, and when I say deposit, guys, it is any deposit. It is not public deposits. Public deposits is given in 72, 73, 73, 74, 75 sections. Deposits by the public only. No. Deposit includes any deposit. Should not be understood as public deposit, but deposit defined under 73. Or as deposit defined in 73, it is a deposit under 231. Interpretation of statute. Litera legis. But all deposits of money, including intercorporate deposit, security deposit, dealer deposit, everything. Everything is covered in deposit, because deposit includes everything as per definition you saw, except the ones which they say it's not applicable. For example, secured loan. Failure to pay, non-payment, all that we have seen, guys. That's what, see, default to bank and financial institution does not. So it appears for what, guys? Failure continues for 1 year or more. Failure continues for 1 year or more. One more, 164 2A, due date will be there, no? Due date will be 30 days and at 60 days from AGM. From that day only, how many years is disqualified? 5 years. That's what it says here, no? The Act. For a period of 5 years from the date on which the said company fails to do so. Correct? 5 years from what? Due date. But 164 2B, this you need to answer me now. Due date of triple D point. Assume the due date is 30th October 2020. Failure continues up to 30th October 2021. Which means from 31st October 2021, it is a problem. You will be disqualified. Why? It says failure continues for 1 year or more. My question is, you are disqualified for 5 years from 2020, that is till 2025, or 5 years from this 2026? Answer. 164 2B. For 164 2B, the failure should continue for 1 year or more, no? So when is the effective date? Due date will be 30th October 20, just an example. What is the effective due date? 1 year I'll give time, no? Because failure continues for 1 year or more. When is effectively you are getting disqualified? 31st October 2021. Why is loan included in definition of deposit? These are unsecured loans. Unsecured loans, etc. are all deposits now. They wanted to bring all these unsecured loans into the ambit of deposit to follow deposit rules, which are very, very strict. You need to have deposit insurance. Means you have to go to an insurance company and say, I have taken deposit. In case I don't pay, you pay. Insurance company have to take deposit insurance. Will any insurance company give in India deposit insurance? Like I am going to a company, insurance company, and telling I have taken deposit worth 10,000 crores. If I don't pay, can you pay? Will any insurance company give? No. No insurance company even offered any such thing. So that was deposit insurance concept was a failure in India. So due date was what? 30th October. 1 year is what? 30th October 2021. When is the effective date when you will commit a default? 1 year. But my disqualification now will be 5 years from due date or 5 years from effective due date? Five years from due date, that is 30th October 2020 to 2025, or is it from 21 to 26? What do you think? If you say due date 20 to 25, then in 20 to 21, 1 year relaxation. Correct, no? If you say the disqualification is from 2020, that is due date, to 5 years. When will the disqualification take effect? Only in 2021, which means 1 year relaxation, automatic. Is it like that? Or 2020 to 2021 is anyway 1 year, this will take effect, and from here 5 years. What do you think? You read, you will only get the answer. Online answer. No person which fails to do so. Fails to do so means what? Failing to file financial statements on due date. That's fine. Failing to repay deposits on due date, or failing to repay deposits 1 year from the due date. Fails to do so. So 5 years will come from 2021 or 2020. This doubt will only come in 164(2)(b). 164(2)(a), no doubt. Sorry? 21. If this fails to do so, is a common point for both A and B. Don't you think so? Interpretation also should be one only for that. Isn't it a common point? Yeah, fails to do so. So fails to do so is a common point. So interpretation should be same. What is the common point between the two? Due date or effective due date? Due date. So it should be taken as due date only. Means what? 20. You'll be like, nah, I also told the same thing. I know you told the same thing, but the logic is what is needed. Logic is what is needed. Tomorrow, if a client comes, this can be a question also. If the client comes and says, sir, I need an opinion on this. Sir, it's from due date. No, tell me why. No, gut feeling. I know. It is that only. So nobody will pay you any money. Because this is a common point, fails to do so. You can't apply this one for this A, one other interpretation for B. No. It should be the same. And the common link between A and B is what? Due date. So it is due date, which means this is correct. The objective of making a separate clause to B was to give relaxation for 1 year. Though the disqualification is from 2020 only, 1 year relaxation, and 2021 will be the effective date. And you will be disqualified for, some textbooks give from 2021 5 years. 100% wrong. Right? You should write this only. Sir, forget about textbook. What does ICAI say? ICAI also thankfully says this only. I will not tell you what is the right thing, then I will not tell you what to write. No, that will create confusion. There are future things where it requires two interpretation. There I have given in the chart only. What is one interpretation, what is second interpretation, then what is ICAI interpretation. Because we should be more concerned about what ICAI says. Who cares about what I tell? Right? So that I have given. But this, there is no confusion. Some textbooks, some famous textbooks also 100% wrong. This is the correct answer. So I can say that 164(2)(a) is 5 years from date of default. That is very simple. But 164(2)(b), can I say, instead of 5 years from date of default, can I say 4 years from effective date of default? Because there is 1 year internal relaxation. Knowing the correct answer is not a big thing. Why? It is the why that really matters. 1 year internal relaxation. One year internal relaxation. This is what is given here. Now one more doubt, page 47. Because 164(2)(b) has 1 year internal relaxation. Because 164(2)(b) has 1 year internal relaxation, there can be scenarios. You see the table. So director A, B, C is there. Director as on due date, yes, he was a director as on the due date. In my example 2020. And he continues to be a director as on the effective date. Scenario number 1. Director B was a director as on due date. But on effective date, just before that he resigned and he went off. Third one, Bakra fellow, he was not at all a director in 2020. In 2021, October was the effective date. He joined the company in September. What do you think? In each of these scenarios, is the director disqualified or qualified? First one, disqualified. Why? Obviously, he is there for 1 year. Second one, tell me. Director as on due date. Effective date, escape. What do you think? Okay. 164(2)(a) is punishment for non-filing or punishment for delay in filing? Non-filing. 164(2)(b) is punishment for not repaying or paying, or punishment for continuing the negligence for 1 year. Continuing the negligence for 1 year. But if this fellow has not continued, Because if you see the wordings, what does it say? There's one clear word. Continues. Failure, continues. 164 2b is for negligence. Correct. No person who is or has been. So what is the interpretation? Tell me. He will be disqualified. Okay. So you are saying that if he escapes like that, he will be disqualified. Now I will give you one more scenario. I know that the company has not paid. I am a director. I have been telling the company, telling the other board to continuously, I am telling, for them to repay. They are not doing. I have sent them many mails. Due date also over. After due date also many mails I have sent. They have not done anything. Now I will send one more letter saying that I have been pushing you to do it. You are least bothered. I don't want to be disqualified. I am resigning. Thank you. Now will I be disqualified? Why? No person? No, but person only. I am saying that I have been pushing, but company has still not done. What does the law say? No person who has been part of the company which. Company is not paid here. But I am pushing the company to pay, they are not interested. So I will send a final mail saying that please accept my resignation. I don't want to be disqualified. I have been pushing you, it's your mistake. So I am resigning now before the effective date. What do you think? Which links me to another section, resignation. While resigning, should I mandatorily give reason or I need not give reason? While resigning, should I give reason? I am resigning. Why? Just like that. Can I tell like that? Read 168 and tell me. 2 days over, this fellow, one section also is not finished. Like that you will be thinking. 2 days, one section. 470 sections, 940 days. Proviso. Director may resign. Okay, that's his choice. Proviso. Director may also forward copy of the resignation along with detailed reasons. May also forward. Discretionary or mandatory? Discretionary. Actually, it was earlier mandatory. They changed it to, earlier it was director shall also forward. Now they made it discretionary. Your wish. You can simply say personal reasons. No need to give full reasons. But tell me, so generally that link question is here only. Is recording reasons by director under 168 mandatory or discretionary? Discretionary. As per 168(1) proviso. But tell me one thing, if this director wants to escape disqualification, shouldn't he give reasons along with the full attachment of the full mail trial where he has been demanding repayment? Yes. Correct? So that may will be read as shall in case of a director under 164 2b who wants to resign after putting full efforts to claim, to get repayment or payment. It says no person who has been a director of a company which has not paid. A company is doing a mistake. I am pushing. Other directors don't care. I don't care about it. There can be two types. Point number B can be of two types. One fellow who only wants to escape. 2 days before effective date, he'll resign. He doesn't give any reasons. But there is other guy with proof. He has sent so many mails unanswered. Who will be protected? A genuine director will be protected. This fellow has no mails, nothing. Suddenly he resigns. He will be disqualified. So it is either disqualified or qualified as the case may be. Here may will be read as shall. For a director who wants to resign after company has failed under section 164 2b, he has to give reasons plus proof. He has to give reasons plus proof. May will be read as shall for a director who wants to resign after company has failed under section. US means under section 164 2b. He has to give reasons plus he has to give proof. Only then he will be saved. Some other directors Chumma wants to escape, he will not get anything. Will director be liable for acts of other directors after resignation or removal? So he will be liable for acts of other directors after he resigns. What do you think? There only 168 as your answer. The resignation of director shall take effect at you leave. See, the director who has resigned shall be liable even after his resignation for the offences which occurred during his tenure. Correct? During his tenure, if he committed any offences, yes, of course. But for acts of the directors after his resignation, no. Right? So he'll be liable for what? Liable for offences committed during his tenure. Won't be liable for acts of other directors after resignation. What about this Bakra fellow? Papa, on the day of default, he was never there. 2 months ago, he came. For him? So there was confusion. Will he come? Will he not come? He should have seen all that they used to tell. So to give one relaxation, they amended the law and inserted a proviso. See here, last proviso. Page 44. This was the proviso inserted. Amendment. Provided that where a person is appointed as a director of a company which is in default of clause number A or clause number B, he shall not incur the disqualification for a period of 6 months from the date of his appointment. So, from the date of his appointment within 6 months, if the effective date comes or if the due date comes, he will not be disqualified. But if he came 2 months before the 2 months after the due date, then yes, law will not protect you. Law will protect you only if you are a new director. So they tell him, please force the company to rectify the defect, or you please resign and go. I know you're a new director, but disqualification date is coming. You resign or go, or you please ensure that the company fills up everything. Clear? So if you see, for the Bakra director, there is some relaxation. So for this guy, where did it go? There is a relaxation. The proviso, which is there again here, this one, breather, page number 48. Where a person appointed as a director of the company which is in default of clause A or clause B shall not incur the disqualification for a period of 6 months. Means what? Rectify or resign. This is a good provision. There are many new directors who didn't know what to do. There was confusion. When they went to lawyers, chartered accountants, companies, they said, sir, out of syllabus. This I didn't study in my exam. I don't know what. So that's why they told their other lawyer, chartered accountant friends who are lawmakers, which are change of the law. So they changed the law. It's a good provision, 6 months. So 2 months after due date you came, you still have 10 months, no? Please do something. Then no relaxation and all. But you came new, some 3 months ago you came. Today is the effective date. So you either try in this 3 months, you should have tried. If you have not tried, resign. Now comes to the last question. This they have asked many times in the exam, important. 4 marks question. Mr. X is already a director of company A. Mind you, is already a director of company A, which has made a default in 164.2, either 2A or 2B, doesn't matter. He is also a director in company B. There it's a non-defaulting company. Non-defaulting company. Answer the following. This was November 2017 ka first question also. Should he vacate his office as a director in these companies? How long can he continue as director in both the companies? Can he be reappointed in both the companies? Answer. You see, I'll just show you November 17 paper and then we'll come back to this only. Same question. See. Compulsory question. Mr. Vikram, director of Tube Light, has made default in filing annual accounts and annual returns. Whether Vikram can continue to be director in both the companies. Also state whether he can be reappointed in both the companies. What if your answer be defaulting company is a private limited company, like that. Anyway, private, public, now for us, no tension. But the same question I have modified and made it like this. It's easier. Tell me. Third one can be, see, disqualification will come only at the time of appointment or reappointment. In this question is already a director. So 2 questions you have to answer. When he is reappointing, when he is being reappointed, can he come inside again? That is question number 1. Second one is already inside. Will he be thrown out? Got it? Third question is easy. Can he be reappointed in both the companies? For that you have the answer, no, in 164. What is 164 answer? 2. He shall not be eligible to be reappointed as director of that company or appointed in other company. That company means what? Defaulting company, or other company means non-defaulting company for a period of 5 years. For a period of 5 years from the date on which said company fails to do so. So what is the answer? Can he be reappointed in both the companies? Yes or no? No. For 5 years. That is very easy. As per 164(2). Now, first and second are related. Should he vacate in his office as director in both the companies? How long can he continue in both the companies? This is where 167 1A comes. 167 1A. What does 167 1A say? He should, office of the director will be vacated if he incurs any of the disqualification on 164. Which means he should get out in the defaulting company, other companies he can continue. But change happened, no? What change happened? Continuing in the, that ulta change happened because of the lawyer scene, I told you. We just discussed that already. This proviso was added. Where he incurs the disqualification under subsection 1, subsection 2, sorry, of 164, office of the director shall become vacant in all the companies other than the company which is in default. Means in this particular question, shall he vacate in both the companies? Vacate in which company? Vacate in B. Continue in A. Why? 167 1A proviso, which is an amendment. Got it? So coming back here, tell me, if there is a disqualification under 164(1), call money and all those things, in the defaulting company, will I vacate or not vacate? Vacate. In the non-defaulting company, I will continue. But for reappointment, will I be disqualified? For reappointment, will I be disqualified? Yes. Disqualified for reappointment. Here also obviously disqualified for reappointment. Obviously. Disqualified for reappointment. One 164(2). Defaulting company, can I continue? Yes, continue. But am I disqualified for reappointment? Yes. Non-defaulting company, vacate. Ulta, that's all. In all the cases, I am disqualified for reappointment. This is because of which one? 167 1A proviso. This is simply 167 1A, that's all. One is 167 1A proviso, one is 167 1A, that's all. Is there any relaxation in 164? Nothing is there. No relaxation whatsoever. No relaxation whatsoever. Nobody can relax. Court, gate, nothing. There are certain things that I found interesting I have given here in the thing called for the love of law, that you can keep going through, that we'll see. So we still have a couple of things, we can take it up later, no problem. Tomorrow there is no class, enjoy, because I told you when I start first couple of weeks, it's a thing that I have observed over the last 10 years. I've been teaching since almost 10, 11 years now. When I was a student only, I started teaching. So I have observed that when I start the law, couple of weeks, you need just 1 day breather. You also have office, you also have other things. So you need 1 day off. This will not be given every time. This will be given for first 2 weeks. After that, you will get adjusted. After that, no choice. We are all here to die anyway, 5 years. But then in law, because you attended this entire week, whenever we start, fine, you have attended, and you just need a breather. Then again next week, 1 breather. After that, there will be no breathers. So we will take classes regularly. So 1 off you also need to rest, get your mind off of law. Don't sit and study law tomorrow. Today you study, but every day you need to study, guys. I hope you are doing it. Take time off, half an hour. I don't know how you do it. That day's class should be finished. And tomorrow, if possible, I mean, don't study specifically. In the evening and all, when you chill, half an hour, you can just revise whatever we have done the entire week. That is the only way which can keep you, motivated and also understand everything. That's the thing. So whatever we are doing only is running notes, but I'll give you more tips of writing how the running notes and all those things. So we'll meet day after tomorrow. Same time. Till this, anyway, we've done only 1 section, but so many things are there. All sections are not like this. Some sections are very easy. Some sections are very tough. Cluster 3 is the deadliest cluster. Every section will take minimum 3 classes. Dangerous. I mean, it's very easy, but then so many interconnections. And the best part is, in the exam, they'll give a question on cluster 3 and say, comment as per Companies Act. That's all. You need to connect 4-5 sections. I told you there are 3 things. One is comprehension and knowledge, which is copy paste. Second one is analysis. Third one is evaluation and synthesis. So some clusters will be based on evaluation and synthesis. You only have to figure out which one. Right? Okay. So take a break tomorrow. We shall meet day after. Okay. Online people, tomorrow you can aram se sleep. Today you are sleeping and you can see my video. Tomorrow you can sleep aram se. See you day after. Okay, bye, take care.